May it please the court, my name is Mitch Raines. I'm with the Public Defender's Office, and I'm here today on behalf of Mr. Tomar Beard. At this point, I'd like to request 4 minutes for rebuttal.
4 minutes?
Yes, Your Honor.
All right.
Thank you.
You bet.
In this case, we have raised 2 issues for this court's consideration. The first is the trial court's error in excluding Mr. Beard's mental health expert from testifying at trial. And the second issue is the trial court deeming Mr. Beard competent to stand trial both the day before trial was scheduled to begin and then also the morning that trial was to commence. For purposes of argument, I'm going to focus on that first issue, but of course if this court has any questions, I'm happy to try and address any of those as they relate to the second issue. But to the first issue, I think it's important to first start off with maybe an overview of the terminology that comes up a lot with these. So we have results and reports, summary reports, and then draft report. Results and reports is the term that is used by the operative law, which is Rule 16b of criminal procedure. Summary reports is a term that comes from the Tennessee Supreme Court saying that a summary report is sufficient to meet the disclosure requirements of Rule 16b. And then draft report is, I guess, best describes what the report that Dr. Zager prepared self-identifies as. She mentions in there that it's a draft report. So just kind of give a bit of context for all of that. Our position is that all of those mean the same thing, and whether a report be a draft report, a summary report, or results and reports, it all is the same thing under Rule 16b. And the purpose of Rule 16b is that it provides notice to the state, in this case, and time to rebut the expert opinion as described in the report and as proffered by the defendant. And that comes from a case out of this court, State versus Henry, I believe, in 1999.
Okay, and Dr. Zagers, from her testimony, if I remember correctly, she admitted that her draft report didn't really have any information about how she formed her opinions that another expert could look at and say, okay, this is why she made her opinion.
That was in response to state's questions.
But still, that was her testimony, right?
It is, yeah. They went through a back and forth with the state's representative where certain information that the state thought that Dr. Zager should have considered and hadn't considered. They went through a whole litany of those.
And she from her testimony, admitted that she didn't and probably should have.
That is correct, Your Honor. That does not render her report not a report, though, and it doesn't invalidate the opinion that she issued in her report as well. So, the purpose behind Rule 16 is to put the state on notice that expert testimony is going to be utilized and allow them an opportunity to basically get their own expert to rebut that. That Dr. Zager didn't consider certain information, I think is certainly appropriate for the state on a cross-examination to try and elicit, to impeach in front of a jury as to why their expert's opinion is more well-reasoned than hers, that sort of thing. But as a baseline, the report that she provided gave notice to the state, and it also provided all of the requisite information that would have allowed the state's expert to identify the purpose of her report, the information that she considered in her report, how she reached her conclusion, and also what her conclusion was.
But she didn't provide all that. That was not provided in a report.
It's my contention, Your Honor, that that is provided in the report.
All right, so the report from Church Healthcare was not included?
So let me back up for just a second. Dr. Zager's report is the summary, basically, of her analysis of Mr. Beard and then her opinion as it relates to that analysis. And it contains a description of the information that she utilized in reaching that opinion. The Christ Community Health Services records are physical mental health records that are not subject to disclosure under Rule 16 because Dr. Zager provided a mental health, or because Dr. Zager provided the report. The mental health service records, the information from Pathways, the jail records, her personal notes, all of those things would have only been subject to disclosure had she not prepared a report.
Well, that I disagree with, because under the rule, the opposing side would be given access to whatever material she used to form her opinion. And under, like in Flake, I mean, all these notes and analysis that was done by each of the experts had to be turned over before they, or after they testified to the state, so they could see the raw basis of the opinion and look at what they did or didn't do. In this particular case, Dr. Zager admitted that there's a lot of things that she just flat out didn't do that she normally would have done.
I, again, disagree with that assessment that then renders her report invalid, such that she was required to then disclose the physical copies of the mental health records and those things. And I would also point...
The court concluded, though, that that rendered her unreliable.
The court said that that the state was entitled to the documents from Community Health Center, Pathways, those sorts of things, and that those should have been disclosed. My reading of the record is not that the court found her to be unreliable. There was no hearing that covered 703, 702, 705, the McDaniel factors, any of those things that would have addressed the trustworthiness of her results or of the information that she relied on. So I would disagree respectfully with that, Your Honor. And as it relates to Your Honor's point that these records should have been turned over, I, again, would respectfully disagree and direct this court to State v. Nichols, a Tennessee Supreme Court from 1994, where that court found, the Supreme Court found, that this underlying information, as I read the case, is only has to be disclosed or is only available through a forced disclosure by an order from the court if there is no summary report prepared. And the state readily admits that these mental health records, in particular, this information that Dr. Zager relied on, is something that it could have and would have easily had access to. And there's case law supporting the position, at least particularly as it relates to us on the defense side, that if we have the ability to access information, then we cannot force the opposing side to turn that information over to us. It is on us to collect that information. And I would argue that that same burden should also be imputed to the state. And again, there was a mental health report done, I believe it was in November, I forget the year, by Western Mental Health Services, where there would have been access to all of this same information. To that same point, Western Mental Health Services issued what could also be called a report, deeming Mr. Beard competent to stand trial. I believe that was in November. There was an order that he go to Western in October of that year. So some 3 months prior to that, that isn't even as detailed as Dr. Zager's report, but that is something that is just taken at face value when it comes from somewhere like Western Mental Health, that would be a report enough to say that he's competent to stand trial, diminished capacity is not reported, those sorts of things. I think it's also important to note the timing with which this issue came up. So on March 20th of 2022, Mr. Beard filed a notice of insanity and alleging the defense of diminished capacity. The next day, March 31st, 2022, the state filed for a continuance, noting that it needed time to engage a mental health expert and to be able to evaluate basically the proposed testimony or opinion of Mr. Beard's expert. It's not until September the 15th of that same year, 5 days before trial, that the state files its motion seeking to exclude the testimony of Mr. Beard's expert testimony, of Mr. Beard's expert witness, excuse me, I'm getting tongue-tied over here. This court has held in State versus Anderson that there's no relief warranted where a party had knowledge of a discovery defect and then has failed to seek a remedy. I would put forward to this court that 5 days before trial, alleging that a mental health expert by the defense is insufficient to the point that exclusion is then necessary, is untimely. I would also note that Rule 16D2 lists out, I think it's 3, there may be more, potential remedies or sanctions that a trial court is allowed to impose if there has actually been a discovery violation. Our position is that there is no discovery violation. Full stop. All Mr. Beard was required was to disclose the report of his mental health expert. But even if that wasn't sufficient, the trial court's imposition of a sanction excluding his mental health expert was improper. This court, again in State versus Smith, it's from 1995, has said that that drastic remedy should only be implemented unless there is no other reasonable alternative here. Here, a very reasonable alternative would have been grant a continuance, require that Dr. Zager produce another report that meets whatever definition the trial court wants to set, or order disclosure, hand over copies of all of these different items and things. If there are no further questions about that issue, I'll move on and just briefly address the second. Unfortunately, I do agree with the state that that issue was waived. It was not included in the motion for new trial, but that plain error relief is still warranted there. The state argues that the record is insufficient for this court to evaluate that issue. I respectfully disagree with that. We do not have a copy of the motion that was filed. It's not in the record. I checked the docket. I don't believe that there was a formal one filed. The record seems to indicate that, but I don't think that one was actually filed. We do, though, have a transcript of the hearing that was held on the motion to continue, where Mr. Beard's attorney explained that the reason why he was filing or seeking that continuance the day before trial was because he had had difficulties conferring with Mr. Beard, such that he thought there might be an issue. He asked Dr. Zager to interview Mr. Beard, and based on Dr. Zager's interview with Mr. Beard, discussions with jail staff, discussions with his attorney, and her previous review of his mental health records throughout the years, that he was not competent to stand trial. Dr. Zager testifies at that. The state's allowed to cross, and the trial court issues an oral findings and an order from that denying the motion. That is then again renewed the next day, the morning before trial, and again the trial court denies the motion to continue. So I would say that the record is sufficient. We've also supplemented the record with a copy of the letter from Western Mental Health Services that the trial court references at the hearing. So again, I think the record is more than sufficient to allow this court to evaluate this issue. As it relates to a clear, and unequivocal rule of law, I would put forward to this court that it is a well-settled right that an accused has the right to a fair trial. And a part of that is to be competent, right? So that they have to understand the nature and object of the offenses alleged against them, and they have the ability to consult with their counsel and prepare in their own defense. If an individual is not competent, and especially in this case where Dr. Zager flatly opined that Mr. Beard did not have the capacity to communicate effectively with his clients, that he was not competent to stand trial, that a denial of that is a clear violates a clear and unequivocal rule of law. And I would also put forward to this court, it appears that the state and I agree that a substantial right, a right to a fair trial under the Sixth Amendment is implicated here. There is no tactical reason for waiver. There's no reason for us to be here under a higher burden other than it just was not included in the motion for new trial. But as it relates to consideration of the issue as necessary to do substantial justice, I would first note that it doesn't appear that that issue has been addressed as to whether it is a structural or non-structural constitutional error by courts in Tennessee. I would put forward that that is a structural constitutional error. One of the most foundational building blocks of our criminal justice system is the right to a fair trial. Inherent is that, in that, is that a defendant be competent when they face trial. If this court deems it a structural constitutional error, then a showing of prejudice is not necessary. If this court finds that it's a non-structural constitutional error, then the harmless error analysis is implicated. And again, I would say that the state is not able to prove beyond a reasonable doubt that prosecuting an individual who is not competent, forcing him to go to trial when he is not competent, is not a harmless error. That certainly impacted, certainly had an impact on the trial. And I'll reserve the remainder of my time for rebuttal. Thank you.
All right, certainly. Before you get started, General, refresh my memory on the date of the crime here, alleged crime, or it's a crime now, he's been convicted. And then what dates are we talking about on go to trial or not go to trial? You ended up going to trial, but I mean, is there a substantial amount of time that has passed between the crime date and the date that the defense wanted a continuance?
I think it was about 3 years.
Okay.
From the offense date to when the defendant first filed his notice of an intent to pursue the insanity defense.
All right.
I think. So there certainly had been some time that elapsed.
Okay.
But on that issue, I very respectfully, I think, disagree with my friend on the other side in saying that reports and results, summary reports, and draft report, those three things do not all mean the same thing. Words are important, and a draft report is just that. It's a draft. That's the specific language that Dr. Zager chose to use in her draft report, which the trial court accurately described as more like a letter than a report. I mean, it doesn't lay out any of the reasons that she reached her conclusion. It's very conclusory. It just simply states that the defendant was insane at the time of the offense and that some medical documents, medical records, and interviews with family members were reviewed. But there's no connection between those things. Dr. Zager candidly admitted that she did not explain how the defendant's records and those interviews with family members, any of the other documentation that she reviewed, she didn't explain how that informed her conclusion, and that anybody reading her report would not have known why she reached her conclusions. And she also admitted that that would have been valuable information for someone to have who was reviewing her report. And so basically what the report, since it was a draft, was going to allow her to do is reach the conclusion that the defendant was insane, but without showing her work to get there, sort of leaving it unchallenged.
Why would
And
the state wait till, 6 months later, less than a week before trial, to then file their, motion to disqualify?
so the record doesn't bear out exactly why the state waited 6 months, but what the record does show is that there was a request between the prosecutor. The prosecutor reached out, I believe, to defense counsel via email and asked for the reports and documentation and data that Dr. Zager relied on.
When was that request?
The record doesn't specifically state when it was, but I think it was sort of guesstimating here, because again, the record doesn't specifically say, like, potentially a couple weeks before trial, but I think it was more than 5 days. It wasn't the same date that the state filed its motion to exclude Dr. Zager's testimony. And when the state filed that motion, I mean, both the defendant and the state are in control of how they pursue their cases. And Here, the state had already reached out and asked for this data that Dr. Zager relied on, and that was denied. Defense counsel refused to turn that over, and so the state was then certainly entitled to seek to exclude Dr. Zager's testimony here. And since her report was just a draft, essentially she was going to be getting in the defendant's medical records and everything else that formed the basis of her conclusion that the defendant was insane. She was going to be getting that in through the case in chief when she testified that the defendant was insane, and the state was therefore entitled to have that underlying data. And the concern that this court recognized in State versus Nichols is the same one that's present here, a defendant taking advantage of discovery rules and essentially skirting discovery rules. That's what the defendant was trying to do here in withholding the underlying data that Dr. Zager used to reach her conclusion. And so when the defendant didn't comply with the requirement of Rule 16 to disclose this underlying data, the trial court then properly exercised its discretion to determine that excluding her testimony was the appropriate remedy here, because there was going to be substantial prejudice to the state if she testified, because the state wasn't going to be able to really test and probe her conclusions without the data that she used to reach her conclusions.
Let me suggest another remedy that might have been, the trial judge could say, okay, you're right, state, you're entitled to all this information, order the defense to supply it to the state, and continue the trial date for whatever. I mean, we're already talking 3 years here, 30 days or something. And everybody, it sounds to me like everybody in this knows that there's mental health issues with regard to Mr. Beard. And I guess my question is, do you agree with defense counsel that it's a pretty drastic remedy to just say, well, your mental health expert is not going to get to testify. Let's get on with the trial, bring the jury in. I mean, that's the impression I got as to what happened.
I would agree, Your Honor, that is a drastic remedy, but it's one that was warranted here. And I know defense counsel and the defendant are arguing that, well, the trial court could have ordered the disclosure for Dr. Zager to turn over this information or continue the case for 30 days. But what's significant is that the defendant never asked for that remedy after the state moved to exclude her testimony. And once the court excluded it, the defendant didn't offer to say, well, here, I'll turn over all of the records, all of the data she used. You can examine it. Can we just continue the case? He didn't choose to do any of that. And it is a drastic remedy, but it's one that the trial court has the discretion to impose. And it's a remedy that's warranted when a defendant is trying to skirt the discovery rules and to not provide all of the information that the rules require him to turn over. And that's why we would ask this court to affirm the judgment of the trial court on that issue. And
Are there other issues where it would have been prejudicial to the state? I just pulled 30 days out of the air, but is there some other reason the state would have been prejudiced other than just, well, you should have given us that information, you didn't, so you don't get to use your witness? I mean, you see what I'm saying?
I think so, Your Honor, just in terms of like the damage to the state's case that...
Like they had their witnesses from out of town who were ready to testify, or, it was about to be the Christmas holidays, or, something other than just, you violated Rule 16, so you don't get to use this mental health witness who might be extremely important in this case. That's all I'm asking.
Right. I don't think that the record necessarily shines a light on another specific example of prejudice like that, like a witness being there from out of town, but there are some references in the record to the fact that the state had made an effort to obtain its own mental health expert, who I think was there to testify at trial. And again, some of the prejudice that could have accrued to the state there is that their own expert doesn't really have the ability to challenge Dr. Zager's conclusion or to challenge the methodology. The methodology...
I don't mean to argue with you, but if the judge had said, give the state's expert what they're entitled to, and we're going to try this case in 2 weeks, then the state's expert would have had everything he needed to challenge, to help the assistant DA or whoever's trying the case challenge her testimony, right?
Yes, Your
That's
Honor.
a good bit less drastic than just saying she's out.
No, I do certainly understand that. That is a remedy that the court could have imposed, but another remedy that was available to the court was the harsher remedy of excluding the testimony here, and the state's position is that it was warranted because prejudice was going to accrue to the state if she was able to testify.
I understand the trial court does have the discretion to do what he did. I didn't mean to seem argumentative. I'm just trying to figure out if there are other reasons besides just we're going to punish you for not, allegedly, he says they were following the rule, but anyway, you got my point there, and you've answered my question. I appreciate it.
Oh, well, thank you, Your Honor. And no, I do understand, and I think there's just not necessarily a lot in the record about the state's underlying motivation here, other than sort of the references to the fact that they weren't going to be able to challenge her testimony. They didn't know what she relied on how she used all of this information to reach her conclusion. And so we would argue that the trial court here, again, acknowledging it is a drastic remedy, but that the trial court properly excluded the testimony. And we would also argue that the trial court did not plainly err by denying the defendant's motion for a continuance here. The parties do agree that this is reviewable only for plain error. And we have an issue with the first factor, and that the record doesn't fully establish what happened in the trial court because we don't have that motion to continue. But even as we move on to the second prong, consideration of this issue is not necessary to do substantial justice here because the defendant failed to establish that he was incompetent on the day of trial. The only proof presented in support of this was Dr. Zager's, again, sort of conclusory allegation that the defendant wouldn't talk to her and wouldn't talk to his attorneys. But what this court has held and what this court has concluded is that when a defendant sort of refuses to participate in the mental health evaluation process, that's not enough to establish incompetency. And that's basically what we have here. We have the defendant who was evaluated by multiple mental health professionals, including Dr. Zager, and found to be competent to stand trial. And what's significant about the change in Dr. Zager's position is she never really explained what changed in the defendant between those evaluations. She never said sort of what shifted and what caused him to no longer be competent to stand
trial. Wasn't there some proof that when he was, I think, first evaluated, that yes, he's competent, but he's going to need ongoing medication, treatment to remain competent? And I couldn't, from the briefs, see where any of that, whether we know that or not. Did that actually happen? I think there was some allegation he didn't get any medication while he was incarcerated during that period of time. And I guess my question is, doesn't that make a difference when the qualifying report that says he's competent, but he's going to need this to remain competent?
There was that in the initial evaluation of his competency to stand trial, but what we don't have is conclusive evidence of any of the services that he was allegedly denied, any of the medications that he didn't receive. All we have are just allegations. The defendant never specified what service he was supposed to receive, but that the prison allegedly hadn't been providing. And it was the same issue with the medication. There was no proof of a medication that he was prescribed and that wasn't being given to him. We just didn't have any of that evidence. And a defendant is presumed competent. That's the presumption in the state of Tennessee. And the defendant here just simply did not carry his burden of rebutting that presumption and establishing that he was incompetent at the time of trial. And so it was proper for the trial court to deny that motion to continue. And unless there are any further questions.
I do have a question. Going back to the other reason that the judge said that he wasn't going to allow Dr. Zager to testify was, I think he referred to the trustworthiness of her opinion. And the appellant is talking about that, well, what they're talking about, or what the judge was concerned about were things that could be covered on cross-examination, all the things that she didn't consider. But the court felt that by her not considering, at least this is what it appears from his ruling, that all the things that she didn't consider undermined the trustworthiness of her opinion.
Yes, Your Honor, I would agree with that characterization, and I think that is what we had here. And it wasn't something that could have been remedied just on cross-examination. She didn't review enough of the relevant materials to make a reliable opinion in the first place that the defendant was insane at the time of the offense. I mean, she conceded that she hadn't seen the body cam footage after his arrest, the body cam footage from when he was at the hospital, and that all of this would have been really valuable. And she also didn't explain how any of the defendant's underlying health conditions or his medical records established that he was insane at the time of the offense. And so the trial court did properly reason that Dr. Zager can't testify because her opinion simply isn't trustworthy. This is akin to what the same result this court upheld in State versus Lowe, where an expert was deemed to have unreliable testimony and that was properly excluded. And so we would therefore ask this court to affirm the judgments of the trial court below. Thank you.
Thank you, General. All right, Mr. Raines.
Thank you, Your Honor.
Some rebuttal time, sir.
Thank you, Your Honor. I'll start off, Your Honor, Campbell, by addressing the findings that, or the rulings that the trial court made. So in the record, the trial court says that in denying the state's motion that it, quote, found, quote, that the defense failed to provide the documentation and request for discovery concerning her opinions. That they, the state, were requesting information that Dr. Zager had used to come up with her opinions, and that that's what you've got to provide. It appears to the court that the information that she may have relied on was never provided to the district attorney. I mean, they're entitled to review what information she based her opinion on so that they can allow their expert to consider that as well. And again, I think under the proper context, that is the trial court saying on multiple different occasions that it is, Mr. Beard is required to turn over these mental health records from Christ, Methodist, whatever it was, the jail, Pathways Behavioral Health Services, those sorts of things, when Rule 16 says that if you've provided a report, summary report, that you do not have to provide that other information.
But this report, what she provided doesn't come close to answering these questions, though. It's almost like she didn't prepare a report. She just kind of gave conclusions.
Well, Your Honor, I would respectfully disagree with that, and I would point to the report itself where it says, regarding mental condition at the time of the offense, Mr. Beard was suffering from a substance-induced psychotic disorder at that time. At the time of the offense, Mr. Beard was psychotic, suffering from delusions, experiencing hallucinations. He was also using amphetamines, these other things. There was a urine screen. And all of those sorts of things. And then it says, it's my considered opinion that Mr. Beard could not appreciate the nature and wrongfulness of his behavior at the time of the offense due to the substance-induced psychotic disorder. It seems likely this is a case of settled insanity. And I would put forward to this court that I'm certainly not a mental health expert. I don't know what all of these terms and terminology means, but there's nothing in the record that supports that the state ever provided its mental health expert with this document and said, my expert says I can't figure out what yours is saying, that sort of thing.
But Dr. Zager admitted that that information in there is not sufficient for someone to understand how she got her conclusions. And that was her testimony.
I do agree that she said that she wished that she had more information, that she had had access to different information that had come in light since she had conducted her evaluations and things of that nature.
And she said it was a mistake for her not to include certain things in her report.
That's correct, Your Honor, but I do still think that taking this report at face value, which is what we should do, because the purpose of this report is to provide notice to the state and allow their expert to determine determined what she's utilized and how she's reached her conclusion that this is still sufficient. I'd also just like to briefly address, Your Honor Wiedemeyer, you asked about the timing of this case. So the offense date was February 20th of 2022. The trial date was September 20th. The offense date was February 20th of 2020. The trial date was September 20th of 2022. An indictment wasn't issued until February 28th of 2022. Then on March 30th, Mr. Beard provides his notice. On March 31st, the state asked for a continuance, and then nearly 6 months later, the state finally, for the first time, reaches out to the trial court to either allege that this is insufficient and they are entitled to more discovery, or to bring it to the trial court's attention for the first time. And I'll just ask for the relief sought in the brief, and thank you for your time. Thank you.
All right, thank you. Excellent briefs by both sides. We appreciate that, and we appreciate the arguments. We'll take it under advisement. We're just going to have a very short recess here and then come back and finish up our last case.
All right. This court is in recess.